going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great night so far. All right. I've got almost an entire Judge Simpson docket. Yeah, I've got a lot of Judge Simpson tonight. I watched his entire docket today, and Thursdays are usually really good days for Judge Simpson. Today was no exception. Not a lot of Mr. Allens, though. Not a lot of them. There were some, not a ton, but I did grab the ones that were there, and I got some of the interesting ones, and then we're going to finish with a Judge Middleton case. All right. Yeah, that's all I got. Thank you guys so much for being here. Let's go. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Let's call the case Bieber versus Emily Bates.
Counter Alexis Puma appearing on behalf of Emily Bates. Any chance Miss Bates is present over Zoom?
Emily Bates? Nope.
Counter, I have not been able to reach Miss Bates. She typically does appear over Zoom. I don't think she has failed to appear since she's been having probable cause conferences, and this is the first time that I or anyone else from my office has been unable to reach her, so I'm not sure what's going on. She's usually very responsive. I would request an adjournment.
Bench
The court
warrant will
would
issue for
consider it.
defendant's failure to appear. Bond set at 10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Thank you.
All right. I don't know why I kept that in there. That should have been cut out. I really hope this next case is the one that I wanted to start the video off with, because it clearly wasn't that one. Yeah. All right. Let's go.
Court calls the case People versus David Stevenson White.
Absolutely, the people.
Good morning, Your Honor. Hannah Mackey requesting permission to practice under Michigan Court Rule 8.120 under Assistant Public Defender Jay Bellinger.
Really?
I know.
Bellinger?
I don't have any t-shirts today for you.
It's okay. All right. Permission to practice is granted.
Thank you, Your Honor. Your name for the record.
David Stevenson White.
Oh, you didn't get her name. What's your name again?
David Stevenson White.
No, not you.
Oh.
I know what your name is. I got your file. You're in green. I got you.
Yeah, all the
All right. Your
Han-
name.
Hannah Mackey.
Got it? Hello.
Makki.
Have you appeared before me before?
Not before you.
I
no.
didn't think so. That's why we don't have any.
That is not Jessica Blanche. That is a student attorney that came in dressed to impress. She looks good. She does. She's wearing a nice suit and bright colors. Look, with this pulled back, she resonates with the entire courtroom. Remember when I was there and I wore that bright blue shirt? This is why. Because when it pulls back like this, I wanted you to see where I was. I feel like she did that on purpose. She was watching my videos. But no, that is not Jessica Blanche. That is a student attorney.
Where are you from?
Where?
Where? That's a question. Yes.
Like Michigan,
Okay, that's a good start. What part of Michigan?
Ann Arbor.
You're from Ann Arbor?
Yes.
Where'd you go to high school?
Divine Child in Dearborn.
Oh. Couldn't stay here.
Oh, that's a good school.
Where'd you go to undergrad?
Doc Ock, I hope you're well. Sorry you've had a tough week. Sit back, relax. Maybe have a beer, a glass of wine, however, whatever you do when you choose to relax, you do it. Hopefully you're not still at work. But Doc Ock, it's good to see you, bud. And since Doc Ock is here, I am debating. Haven't made the decision yet, but I am debating on making an impromptu trip to Detroit tomorrow. Court's been kind of slow this week, so I don't think I'm really going to miss anything. But I want to go say hi to Judge King since he's back on the bench and kind of do my rounds up in the Detroit area. What do you guys think? Should I do it? I don't know. It's going to be a long day. It's going to be an early day. But it's been in my head since I woke up this morning. Like, let's just do it. Fridays are landlord-tenant days. They're generally slow days for court. Why not? I can get there early, leave by lunchtime, and be home in time to stream tomorrow night. What do you guys think?
Michigan.
Where are you in law school now?
It's just gonna get worse every time you ask. Michigan State.
Should have said no.
Yeah. Probably should have just not told me the truth. Okay. It's okay. We got you. We'll talk slow. All right. Sorry. Had to take the shot. What are we doing in this case?
Your Honor, Mr. Stevenson is prepared to waive his right to a preliminary examination.
Sir, is that correct? After all that?
Yes.
Okay. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. I'm sorry. And you understand that you'll not have that hearing and you'll proceed to circuit court for further resolution. Yes, sir. All right.
Your Honor, we waive formal reading of the complaint.
Whoa.
Acknowledge receipt of my client's.
Whoa. How'd she just do that? Bellinger.
Yes, Your Honor.
She just started jumping in.
Well, Your Honor.
Okay, all right.
I was told when you look up at me to say it, so.
Is that what Bellinger said? Is that what he said? Oh, don't listen to what he says. When he looks at you, do something. Listen, okay, just slow down. Okay? People also waive their right? Yeah, you forgot that part. Who's?
He's looking at me.
I'm like,
Do something.
Am I in the middle of this?
No, you're good. No, you're good. It's the attorney. They're out of control.
The defendant, the person who should be kind of the center of this whole case. He's just like, what is going on? Am I in the middle of this? Everyone's laughing. The prosecution's laughing. Judge Simpson is just messing with the student attorney. Where are you from? And the student's like, I was told that when I answer these questions, it's going to be bad. She doesn't want to answer the question. So he's having fun with her. This is a great way. This happened this morning too. This was a great way to start the day. If only it could have stayed that way. But it's a great way to start the video as well.
It's not my fault.
No, this is not your fault. The other part was.
Yes, Your Honor.
Do the people waive their right?
To a preliminary exam? Absolutely.
Okay. Preliminary examination having been waived, defendant is bound over to circuit court on the single charge. Now I'll look at you. Go.
Your Honor, we waive formal reading of the complaint, acknowledge receipt, and my client will stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
October 22nd, 1:30 before this.
October 22nd, 2024, 1:30. Bond will continue. You made it through. You're good. What?
I've seen Miss Conky today too, I think.
You do?
I believe.
Yeah,
If I'm not mistaken.
Okay, well, good luck. All right.
Sir,
Thank
may I
you.
request
Take care.
any information?
Yes.
Thank you.
Oh, is she? Don't be embarrassed. You're good. You're not? I would be. All right, so.
All right. I kept three cases in a row, so I don't have a little divider in between. Doc Ock, yeah, no, you don't have to ask. If I say I'm going somewhere and I go, absolutely. And Doc Ock, you have my number. You can just text me, like, are you going? I'm down. Let's go. Anyone's invited. I mean, the court's a public place. I don't go there, and try to seclude myself. No, I love it when people come with me. And I've yet to go alone, actually. So, but you're saying you're going to Missouri. Is that what you said? Did I read that right? Yeah, but it honestly depends on whether or not I wake up and I feel good enough to go. So it's I mean, I'm not saying I don't feel well. I feel great, but I have to wake up at about 3 a.m., shower, get dressed, and I have to leave my house by about 4 a.m. to make it by the time court starts. So that's the hard part. So if I wake up at 3 a.m. and I'm just like, nah, I'm not doing this today, then I won't go. But I'm really I'm pumped to go. So I think I'm gonna do it. Oh, thanks, David. I appreciate it. Yeah, Arkansas, Kansas, Missouri. Yeah, they're all kind of right there in the middle. Yeah, same thing. they're not, but yeah. Sorry, I misread what you said.
Court does call the case. People versus Teressa Johnson. She's in Zoom.
Yes, sir.
Oh, and you're back.
Hannah Mackey, on behalf of Miss Teresa.
Teressa Johnson.
Miss Teresa.
She's in Zoom.
Oh, she's on.
Is she in Zoom?
Okay.
Okay.
What? Would they just give you the hard cases or what?
It's getting worse when I ask what I'm gonna say next.
Thanks for the warning. All right.
Your Honor, we asked
Go ahead.
to adjourn this matter to 3 weeks, and we'll seek to move it up on the docket if and when appropriate.
Pardon? You want to do what?
Adjourn to 3 weeks?
Any objection from the people?
No, Your Honor.
October 24th, 2024, 9 a.m. And what else did you want to do?
That was all.
Okay, good. Fine, we'll continue.
Thank you.
It's gonna be a long, here, you do these, because I don't know what she just did. Oh, I don't need these out unless I'm waving. Did I wave these? I don't need this out.
Oh, gotcha.
Just call the case. People versus Dolores Strickland. Yeah, relax. Go ahead, have a seat.
Ready, Judge Torshell Feaster, Assistant Public Defender, appearing on behalf of Miss Dolores Strickland. Miss Strickland, please state your name for the record.
All right. Hold on. I want to give the shout out properly. I know who it is, but I don't want to be wrong. Miss Bonnie. Miss Bonnie let me know that this is the one and only Rosebud. Now, without her being on Zoom with the name Rosebud, I have no idea. I don't remember what her name was, but according to Miss Bonnie, this is Rosebud. Miss Bonnie, if you're watching, thank you so much for letting me know this was going on. No, you also did the same thing. So, Miss Bonnie's like, Rosebud's in Judge Simpson. No's like, oh my God, tell me you're watching Simpson right now. See, two completely different messages. But let's go. This one's weird.
230 times Dolores Strickland.
Thank you, Judge. I have had many conversations with Miss Strickland, and we were working with the people, with Miss Tana, to try to resolve this matter. Miss Strickland had a particular offer she requested. I asked Miss Tana for that.
You asked?
Miss Tana.
How'd that go?
She was not willing.
Yeah, I didn't.
To give Miss Strickland the offer that she wanted. Then I sent Miss Tana the mitigation letter just to make sure she had it, because Miss Strickland wanted you to have it and Miss Tana to have it. I told her this was not the point for Your Honor to have a mitigation letter, but I did make sure Miss Tana had it. And you're asking for another adjournment so Miss Tana can consider the offer in light of the mitigation letter that I have made sure she had per Ms. Strickland's request.
So do we have the,
And also, can we do that as soon as possible? Because I've been in here, Your Honor, 230 days today, and I've got absolutely nowhere. And I also sent you the mitigation letter and a letter in the mail just recently. So you'll probably get that too.
okay. I know you've been in a while, but I also have 3 cases. So that may be part of the problem.
Altogether, from what I understand,
If I might, Judge, Ms. Strickland is hoping for a resolution that will not include any type of probation.
Oh.
And that is not what is being offered at this time. And that is going to possibly be a hangup to resolve this matter.
And Your Honor, I told him that I would maybe consider it. It depends on how long it would be. But however, I do have family in Florida, that Tallahassee, the hurricane, things like that I really need to get out to see if they're even alive or what happened to them, because I can't find nothing out in here. And I talked to them through Messenger. That's the way I stay in touch with my family. And I know they got hit. I just don't know how hard. And I can't get no information because the only person that I have here is my ex of 15 years and my other kids that, I don't have their number right now either, because I cannot get to their number, and I do not have phone, which I need to ask Your Honor, can I get my phone privileges back on, please?
I believe they were restricted because she had contacted.
Because she violated a condition of bond, so I revoked it.
Correct.
I was already punished for that, Your Honor, because he had them block his number. So that should have no problem of me calling my brother and trying to get help from him or, contact him, because that's who I was contacting. I wasn't contacting my ex.
Okay, Ms. Strickland. Now, a lot of these requests that you're making.
It's because I got nowhere.
Okay, listen. You need to talk with your attorney about them.
I have. Your Honor, I have.
Do you listen to your attorney as well as you're listening to me? That means not at all.
I got mental issues that just like I'm overwhelmed, very much so, Your Honor, but go ahead.
Thank you. Talk to your attorney about these issues. He'll talk to the prosecutor. They'll see what can possibly be worked out, if anything can be worked out. I'm not reinstating your phone privileges. You violated that condition of bond. That will continue revoked.
Then I just continue.
Okay.
Sorry, Judge, if we could have an adjournment so that Ms. Tana and I'm bad with names.
Ms. Rizmersky.
Ms. Rizmersky. I knew the first name. Ms. Rizmersky could consider Ms. Strickland's.
How much time will it take for them?
We only need a week or two, Judge.
A week, please, Your Honor. A week. Let's speed this up, Your Honor. I'm trying to. If you just read my mitigation letter, Your Honor, you can find out why.
Ma'am, that's a problem. You keep doing things that your attorney says it's not the appropriate time. When I get that letter into my office, I'm going to tell you I am not going to review it because it's not appropriate for me to see that. If you listen to your attorney, maybe this would go a little bit smoother.
Your Honor, my attorney's not telling me what I need to know. I'm lost.
No, your attorney's not telling you what you want to hear. He's telling you what you need to know. You're just not listening, like you're not listening to me. These matters are adjourned to the 17th, 9 a.m. Bond continued. Thank you.
Thank you, Judge.
Here, you do this. I didn't do any.
Thank you, Judge.
I'd like to say the same to you. Court does call.
Feasters and Judge Simpson's relationships their relationship is awesome. First and foremost, KCC, thank you so much for the raid. Welcome to all the KCC raiders. Thank you so much, KCC. I appreciate it. Next up, Mac the Knife, member for 5 months. Words are hard. Thank you so much, Mac. I appreciate it. Oh. All right. We got more Judge Simpson. We got a lot more Judge Simpson. All right. Let's go.
Court does call the case of the people of the state of Michigan versus Maurice Todd Anthony. This is on case 24 F5 5655.
Thank you, Your Honor. Actually, allowing to the people.
Honor, Lauren Brown, Deputy Chief Public Defender. Has our office been appointed in this matter?
That you have not. Mr. Anthony, you are before the court on a felony. That complaint alleges that on or about May 10th, 2024, at the location of Liberty Street near Maynard in the city of Ann Arbor, Washtenaw County, state of Michigan, that you did knowingly possess less than 25 grams of a mixture containing the controlled substance of cocaine. You understand the nature of that charge, sir?
Yes, sir.
All right. That is a felony punishable by up to 4 years incarceration and or a $25,000 fine plus court cost. Do you understand that?
Yes, sir.
All right. Now, first question I have for you, sir, is do you want to be represented by an attorney?
Yes.
Public defender case.
Thank you, Your Honor. At this time, we are respectfully requesting that my client.
Thank you so much, Stephen. I appreciate it. Thank you so much for the milestone. 3 months, that is awesome. Thank you so much. Thank you so much. I appreciate you being here.
Be allowed to enter a plea of not guilty, and that a probable cause conference date.
All right. Waive the timelines on this so I can set it for the same one.
Yes, please.
All right. Defendant having pled not guilty, demanding a preliminary examination. I will set a probable cause for October 24th, 2024 at 9 a.m.
May we address the issue of bond?
You may.
Your Honor, my client has appeared certainly court dates which were set. I believe that it's a danger to flee. He will again continue to return to all future court dates. We're asking that the court set either a PR bond or a bond of $5,000, 10% allowed.
Any response to bond from the people?
Your Honor, does the court still have the companion file that was up earlier today, 24F20?
I do.
Thank you. Your Honor, in that file, the defendant had not been testing. It appears that the last court date on September 12th, that's not addressed, and we had adjourned again to hire an attorney. But the community corrections report that people have that I'm reviewing, in that case, seems to indicate that he submitted tests on September 4th, August 30th, August 22nd, August 12th, August 9th. The body of the report indicates as well that the defendant was hoping to
Substance abuse.
test at on-site, and the results were to be forwarded, but community corrections haven't received any results. So I originally my office requested PR bond, which does seem to make sense for possession case in a lot of ways. Concern of the people is suggest that the defendant does remain compliant with his bond conditions in all of his pending cases and does test.
In response, Your Honor, my client indicates that he is testing. He's testing Ypsilanti. That the emails to verify his testing have been sent to the wrong court. Can you?
They were sending it to the court instead of the community corrections, which they were, and I told them to, you guys gotta get it sent to the community corrections instead of the court. And he fixed it, and I'm all caught up on all my testing because I've been testing every week, once a week.
Because you're on weekly testing?
Yeah.
Standard supervision. I'll need an order for this file. All right, what I will do in that instance, set the defendant's bond at 10,000 personal recognizance bond, all other standard conditions, including no assault behavior or possession of weapons. You understand that, young man?
Yes.
No possession of possession or use of any alcohol, recreational marijuana, or any illegal drug. I'll order testing, which is consistent with the other thing of standard supervision. And I'll signing that order right now. All right, so I've signed that. Double check before you will release you, before you leave this campus, go over and check with community corrections because you're under a new order, just to make sure they've got it, okay?
I will.
All right, thank you.
Thank you.
Is that it till when? Wow, I get lunch? Wow.
All right, everybody. Before I thank all the gifted memberships, watch what the defendant does. This is actually hilarious. And if I was a defendant, I may attempt to do the same thing. Just watch him. He's in the white t-shirt. Just watch what he does real quick.
I don't know what to do. That's when you eat, right? Okay. All right. I'll give it a shot.
I'd like to say that I have a hard job to do, but I don't want anybody to misunderstand that.
You're just gonna leave?
No.
Yeah.
We decided to mess with Mr. Allen, make a joke, Mr. Allen did not find that funny.
Yeah, okay. All right, I'm out. All right. Well, court stands in recess, I guess, when again.
All right. So Mr. Allen put him in handcuffs, and then he just started walking out the back door instead of going into the jail. He started walking out the back, and they stopped. He's like, "What?" And this Brown's like, "Come on, man, come on." I love it. I love it. Having a sense of humor when being put in handcuffs. I have a feeling that guy understands what's going on. That's funny to me. That was who messes with Mr. Allen. Who would mess with Mr. Allen? He is terrifying. He's a terrifying individual to look at. And that guy looked him in the face like, I'm going to joke with this guy. All right. Anyways, let's get to I'm not thinking myself. Steven, thank you so much for the 10 gifted memberships. Welcome to the 10 new members and Legal Fiction with the 10 gifted memberships as well. Both of you, thank you so much. Mine are free. Mine were free. You guys actually paid for this, and I appreciate it so much. Thank you so much. You guys are awesome. Welcome to the 20 new members. And yeah, I can't tell you how much that means to me. So I appreciate it. All right. We still got more Judge Simpson. We still got, I think, 2 or 3 more Judge Simpson clips before we get to the Judge Middleton clip. Judge Middleton clip's kind of sad. Just to warn you. It's sad and weird and frustrating all at the same time. But we got more Judge Simpson, and we got a sovereign citizen in front of Judge Simpson. All that's coming up. All right, let's go.
Court does call the case. People versus.
Oh, you haven't seen the picture then. I have a picture standing next to Mr. Allen. No. My entire body is about as the size of his bicep. So I am 6'3", all right? I am not a small guy. I am 6'3", and he is at least a half a head taller than me. He is, I'm going to say 3 inches taller than me. I'm going to say he's 6'5", 6'6". And he weighs a solid 250. Just saying. No, not even going to attempt that. Not even going to attempt that. Nope. He could take me. The only thing I might stand a chance on is I might be a little faster than him because he's wearing all that gear. So I might be able to outrun him. But yeah, I'd be running away is what I would be doing.
Javon Smith.
People.
County Water Assistant Public Defender on behalf of Mr. Smith.
Good afternoon, Your Honor.
Good afternoon.
Javon Smith.
Hands in your pocket. You're going to be asking to adjourn the probable cause conference 2 to 3 weeks. There's still some discovery that's outstanding. I'm told that the prosecutor has that. I should have it very soon. And I would ask to address the condition of bond.
Probable cause conference, October 17th, 2024, 9 a.m. Yes, that's Javon.
My client is a football player at Community Christian College. And he has, I think 6 games left in the season. One of those games is in Atlanta, Georgia. One is in New York City. So I'd be asking for the court's permission for him to leave the state to travel to those games. Additionally, I'd be asking for the court to allow either the scram tether to be removed Friday before and then put back on Monday with an ETG test.
What's he been doing all season?
He hasn't been playing.
So what is he? Is he set to play these games? I guess I'm trying to figure out what changed.
He's been getting me documentation to verify that he's on the team. So I wouldn't make the motion to amend his bond until I was given at least some verification. So he's presented me with his class schedule, with his school ID, his screenshots from his the computer system that they use to communicate with the rest of the team, his schedule, his recruitment information. So now that I have that, I was comfortable making the motion.
I guess I'm just trying to figure out. He's on the team. Could have had that to you at any point in time. Hasn't been playing.
Wait until you hear the charges. Just wait. This is one of those. It gets so much worse when you hear the charges.
What is now causing him to play now?
Well, we're asking. I don't understand the question, Judge. We're asking now because now I have the information to ask. He asked me about this weeks ago. I didn't have the verification. So he's been asking for permission to play. I wouldn't bring it to the court until I had independent verification.
So he sat out, what, 4 weeks, 5 weeks of the season. Has 6 weeks left. And now is going to play. That's what I'm getting at.
That's up, whether he's going to play or not is up to his coach. But I'm asking the court for permission so that he can be eligible to do that.
Okay.
Can I respond, Your Honor?
Yeah, go ahead.
Thank you, Your Honor. As the court can see from the phone, this is an OWI causing death case, so it appears to the people.
Boom, right there. OWI causing death. And I'm sorry, he has the balls to stand in front of the judge and say, hey, can you give him permission to travel? You caused a loss of life from drinking and driving. Allegedly, I should have said that at the start. That should be what your focus is right now, man. There are NFL players. The one receiver for the Raiders, who was supposed to be this amazing wide receiver who played in I think it was half his season in his rookie year before he did the same thing, where he was driving his fancy sports car 100 miles an hour down a residential road and lost control and hit someone walking their dog. Yeah, they're not in the NFL anymore. They're in jail. You don't get a. Just saying that. I can't believe the balls of this attorney to ask for this. I mean, I guess the attorney's going to ask. It's not the attorney that's asking. It's the guy. All right, I'm going to start ranting. I have a very big issue with DUIs. I'm sorry. Every time that I hear something like this, I get emotional and I say a lot. So I'm just going to let it play out.
That the defendant is at liberty at all and has a scram tether is frankly quite a gift, given the facts of the case and the circumstances surrounding it. Your the people are opposed to any removal of that scram tether at this time. It does not seem appropriate to allow the defendant to do that. We would ask the court to deny this request. I just was able to receive the MSP lab report, and I just showed it to defense counsel after this case was called, so he hasn't had the opportunity to discuss it with his client yet. But the people are now able to tell the court that the MSP lab report reflects that the defendant's VAC at the time of the crash and death was 0.186.
I'm trying to understand. If I'm the coach of a team, I got a player, hasn't played half the season. Something has to change that says now this person is going to play. Not just that he provided the information regarding that to council.
Judge, it's my understanding he's been eligible to play as far as his coach is concerned the entire time. What he needs is the court's permission. I believe he has been practicing. Is that correct? Have you played in any home games?
Yes.
So he has played. He just hasn't been able to travel. So at the very least, Judge, if the court's unwilling to remove the tether, I would at least ask if the court would allow him permission to leave the state for, there are actually 3 out-of-state games. There is one this coming weekend in South Carolina.
I may allow him to leave the state. I'm not removing the tether. I may allow him to leave the state, but I'm going to have to see a schedule. So understand this. I'm going to deny the motion. However, counsel, I would allow him to leave the state to play.
Judge, I can show the court a copy of the schedule right now.
I'm not going to do it right now. Prepare me an order with the dates that he's leaving. Get prosecutor to stipulate to those being the dates on the football schedule, and the court will sign off.
Thank you.
Judge is pissed. He's not happy about
For
that.
adjourn date.
17th. Thank you.
Thank you.
Have a good
No,
day,
he
John.
does not like that at all.
Thank you.
You could see that. You could hear his tone at the end of that. He is not happy with that. I don't know if he needed to do that, if he felt like he was. I don't know. I've never been a judge before, right? I'm not even a lawyer. But he did not like giving that permission to travel as long as, the dates came in. But it's hilarious that, you're playing football with a tether on. That it's kind of hilarious. Could you imagine? I mean, I'm going to guess he's not the first person to do it. But running down the field with a tether on, the shit, sorry, pardon my French. The smack talk that happens on a field. Yeah. All right, sorry. I'm laughing because I could just imagine back when I played football, back in the day, we would have torn that kid apart. All right, let's keep going. Let's move on for this. But yeah, there's no excuses for DUIs. Well, I'm not going to say there's no, if there's an absolute emergency, and yeah, so there are always, you know what? I just need to stop talking. I need to stop making absolutes though, but DUIs are avoidable. Don't do them, which is why I tell you guys every weekend. Speaking of which, it's Thursday. We're coming up on the weekend. Don't do anything dumb. I will cover you. If you do something dumb, I will cover you. I promise. I will not have any shame about it. No, if you get a DUI this weekend, I will cover your case. And I'll be like, this is no. This is when he fucked up. I gotta stop. I'm getting emotional. I'm cussing. All right, sorry guys. Let's keep going.
So the people versus Zavan Priester.
Ashley wants for the people.
It pleases Honorable Court Jerome Barney, P28321, representing Mr. Fisher, who's standing to my right.
All right. Your name, sir? Zavan Priester. All right. Okay, what are we doing on this case? Because we have let's try to deal with this first. Did you get a copy, Mr. Renner, of the
No, this isn't the soft sit. I think the soft sit might be next. We're not even halfway through the video. So the soft sit is the last video of the Judge Simpson docket. This guy is just a young, dumb guy who, you know what, I'm not going to spoil it. But I will say he gets extremely lucky. Spoiled it. Sorry. Let's go.
probation violation?
No, I did not.
Okay.
I overlooked that in my file. I apologize. It looks like. Jeez, okay.
So you're on a scram tether now, correct? Okay, right?
Yes.
But he's been missing tests, drug tests. Recently for September, he missed his test on the 4th, on the 13th. He appeared for testing on the 18th, tested positive for THC. The 25th, he missed his test. The 30th, he missed his test. And then yesterday, well, not yesterday, on the 1st, he tested positive for THC.
And Your Honor, as I'm reading this too, it looks like there hasn't been a download of the scram tethers since.
Correct. Well, except that I think he went over and downloaded. Is that right?
Yes.
When did you do that? Just recently?
Tuesday, actually.
Yeah, we received an amended, this isn't my amended report, is it? The 3rd?
It is.
Oh, it is.
Yeah, that one.
Yeah, that's everything that I just indicated is on there. It's just that there is listed on there after it says that.
The guy in Zoom is just waiting for his hearing. But pay attention to him because he's kind of laughing and giggling during everything that's going on right now. But the defendant is actually there in person with an attorney that I've never seen before. Judge Simpson knows who he is and has a lot of respect for him. You're going to hear that throughout this hearing. But just watch the guy at the bottom. He's just laughing and smirking. But this is just like a dumb kid. He looks like he's like 19, 20 years old. I have a feeling that he's young. Judge Simpson even says as much. And okay, I'm going to let it play out.
His tether, he failed to report as scheduled for his scram downloads. So it looks like he downloaded finally. And I was going to prepare a warrant to have him picked up because he isn't complying with it. Do you have a medical marijuana card? All right, then so he shouldn't be using anything. Nothing should be appearing in the system.
And I wasn't aware that he was using any kind of marijuana, but now that I'm aware of it, I want to assure the court that he won't be violating any other conditions of this circumstance.
Well, okay, so young man, why are you missing your test?
Rides.
Transportation, Your Honor.
Pardon?
Transportation, lack of transportation.
Well, it's not going to be able to work this way.
Yeah, it's absolutely still an excuse, especially if it's the first time you're in front of Judge Simpson. Now, this kid has a lot of violations. You're going to hear it, but this is why we all love Judge Simpson. Is how he handles this. Again, this is a kid. If this was a grown man, it would have been completely different.
You understand that?
You understand what the judge is saying?
Say it again.
You can't miss for any reason whatsoever.
You just can't be missing tests, and you can't be testing positive for anything.
Employed, am I correct?
Pardon? Oh, okay. I mean, young man, they've requested a bench warrant for you, and I was about to sign off on it until I got the amended thing. I mean, you're coming this close to me just locking me up. You follow what I'm saying? I don't think you want to say it to me that way, young man. Because I can make that happen right now.
Sorry.
So if I let you go today, how am I going to make sure how am I going to make sure you're going to make your task?
Your Honor,
I'll make sure I get there.
we will make sure that he'll get to whatever he needs to get forthwith. I was unaware of this activity. Now that I'm aware.
Yeah, Mr. Bernie, I'm sure that you were. All right, young man, here's the thing. And I'm just gonna make it real clear.
Yeah, you're not wrong. You're not wrong. But to me, if you're under the age of 25, you're a kid to me. I know you're technically an adult, but you're still a kid. You haven't experienced anything. Minus a few exceptions. If you're in the military, obviously you're more of a grown up than I am. But yeah, this is a kid. They never say his age, but I'm gonna guess he's 18 or 19 years old. He's trying to be hard. He's trying to be hard in front of his friends, and hopefully this scares him straight. Judge Simpson's good at that.
I don't want any missed tests. None. Am I clear?
Yes, sir.
I don't want anything in your system. No THC, no marijuana, no nothing. Am I clear?
Yes, sir.
You are also to appear at community corrections and do your downloads of the Scram Tether timely. Am I clear?
Yes.
So there will be no misunderstanding if anything comes back and all of a sudden any of that stuff's missing. I'm not even going to listen to it. I will always listen to what an attorney says and certainly will listen to Mr. Barney, but Mr. Barney will not be able to save you next time.
Right.
Understood?
Sir.
Slondy.
Your Honor, with the court considering ordering levels for the THC, we did have a positive test this week, so we can monitor and be sure that is going down.
I'm not going to order levels at this point because one of the things that happened, I don't know what kind of stuff he's smoking, but it disappears within a week. So it ain't very good.
Disappears.
Judge Simpson, stop. You can't be serious and then try to make us laugh at the same time. I don't know what he's smoking, but it can't be really good because it disappears in a week. He's smoking that reg. That's what he's doing. He's a kid. He can only afford reg. He can't afford the good. Stop, Judge Simpson. Stop it.
Yeah, if you look at his testing, well, it's missed, but I don't know if he comes back with a test and it has THC and it keeps coming back, then they'll give me the levels. I'm not going to worry about it at this point. You understand what that means, young man?
Yes, sir.
So okay, so we can just be clear. If the levels go up, you're going.
Yes, sir.
All right. I'll let his bond continue at this point.
Thank you, Your Honor.
Mr. Barney, what did you want me to do with the case?
Your Honor, we're discussing this matter with the prosecutor's office.
Yes, and my understanding from previous APAs that have been handling the file is that defense counsel was hoping to resolve the case. The people are not quite ready yet to make an offer that would get to that point. We need a little bit more time.
That's correct, Your Honor.
All right.
They want to adjourn for that purpose.
Well, why don't we do it? Well, October 24th work for you, Mr. Barney?
I'll make it work, Your Honor.
All right. October 24th, 2024, 9 a.m. And Mr. Barney, I saw you earlier this morning. Your case wasn't set to the afternoon. So usually with private counsel, we'll set them in the afternoon. But please, sir, feel free to either the day before or whatever, just give my office a call. We'll let you know exactly what time block you're in. So you're not.
Thank you, Your Honor.
I mean, I don't mind seeing you all day, but I think you probably got other stuff to do. So,
Right about that.
all right. So bond will continue, and then we'll have enough drug tests, so we'll see exactly where this young man is going.
Thank you.
All right, thank you, sir.
Does that conclude this matter?
Yes.
There's always one. There's always one. The luckiest person in court that day, probably in that entire courthouse. That kid should have been arrested. He should, or no, his bond should have been revoked for all of his violations. It really should have. Hopefully he figured. Hopefully that scared him straight, though. I really hope he did. I mean, he wore a hoodie, and it's still hot. He's wearing a hoodie to court. Okay, I'm gonna stop. I'm gonna stop judging. I'm gonna stop. I get in trouble when I start judging people. All right, are we doing the soft sit now? Are we on soft sit time, or do we have one more before a soft sit? Let's see.
Your Honor.
Court calls case People versus Jade Lathan.
Soft sit. Let's go. All right, this might be the most boring soft sit of all time, but it's still a sovereign citizen. She will confirm it here in a second. Let's go.
Public defender on behalf of Ms. Lathan, who is approaching. Ms. Lathan, would you state your name for the record, please?
Living flesh and blood being Jade Ruth Bay, beneficiary of Jade Lathan, here under threat, duress, and coercion.
We asked to set the matter for preliminary examination, Your Honor.
Is a violation report. Do you have it?
I do not.
Mr. Allen. Counsel clerk.
Thank you, Your Honor.
Oh, snap. Sovereign citizen walks up. Sovereign citizen opens her mouth. The next thing Judge Simpson says, Mr. Allen. I told you, we didn't get too many Mr. Allens today. We did not. And I let this play out because it was a very quick bench conference. Don't want to spoil it. But, yeah, you're going to see. You'll see.
Thank you for picking up on that. Okay, there is no violation. You want an exam set?
Yes, please, Your Honor.
All discovery is complete.
To my knowledge.
People have their witnesses available the 15th. October 15th, 2024. Preliminary examination in person. That's 9 a.m. That is before Judge Barr.
Thank you. The record, people did make an offer of a misdemeanor at 10 for obstructing. I understand that offer has been rejected. Thank you.
That is correct, Your Honor. I've advised my client of that offer. She does not wish to accept.
Good. Thank you.
Thank you, Your Honor.
All right. Birdie, no, it was not me that said that. It was Sly DeLitch. Is Sly here? Sly, if you're here, say something. No, it was Sly that said it. And it was hilarious. It was Sly, myself, and somebody else. We were sitting in the courtroom. Judge Simpson asked who we were and what case we were there for, because it was at the end of the docket. And I just responded, hey, we're just here for you. Like, we came, we're fans, and we just wanted to come watch you in person. And Miss Ann, his court coordinator, she stood up and said, are you Colin? Because this is back when Judge Simpson still had his chat open, and people in the chat were talking because I was in court. And so she's like, are you Colin? Like, I'm Colin. So everybody's like kind of like talking, like figuring out who people are. And then Sly just looked up at Judge Simpson and said, we didn't just come here for you. We also came here for Mr. Allen. We have a nickname for him. Can I tell you what that is? Judge Simpson just starts laughing. He puts his hand on his face. He full face palms his face and says, like, yes, I've heard a lot of them. What is your nickname for Mr. Allen? And Sly said, we call him the Buff Lift. And Mr. Allen covered his face with both of his hands. He was full body, full shouldered laughing. His face turned bright red. It was an amazing moment. It was an amazing moment. And then when I got home and went back to look at it online, he stopped the live stream before addressing us. So it's not there. So no one gets to see it. But it was a great moment. It's something Sly, myself, and Donald will always remember. It was a great moment. Okay. I think that's it for Judge Simpson. I think we're moving on to is the next one Middleton? Yep. All right. So we're moving out of Judge Simpson's court. We're going to Judge Middleton. And Jody, yes. No, it was a great time. It was a great time. So this one is sad, serious, frustrating, interesting, all at the same time. There's so much going on with this, but there is one thing that I want to say during this clip. So that's the reason why I'm playing it. Normally, I don't like playing the cases that are clear mental health issues. I don't like playing them, but I want to make a strong point about halfway through this. And yeah, so I'm going to share it. Okay, let's go. I don't know. I didn't know there was a defense attorney that's always getting in trouble in Middleton's court. I can't actually say I remember the names off the top of my head from the defense attorneys. The guy that's sitting the two guys that are sitting right there, I couldn't even tell you their name, and they're there almost every single day. Yeah, I'm not good with names in Middleton's court. I'm not. I know a lot of prosecutors and defense attorneys in every other court, but for whatever reason, right now the names are escaping me for Judge Middleton. So I'm sorry. I don't know who you're referring to.
1,000%. That's how the trade-off works.
Yes, Keith Stickley. Keith Stickley. That's who that is. That is Keith Stickley. Then there's Mr. Reed. But Mr. Reed does a lot more. He's a private attorney. Yeah, I don't know. But that is Keith Stickley. I believe that's Stickley.
I got him.
Hello. Might not know the difference, but do anyway.
I don't know a person with better attitude.
All right, let me start the record. As very often happens, sometimes emergencies come up.
Whose name is said in my intro? Oh, you're talking about what's it? Why can't I think? What? You know what? What's it? No. Please tell me you're still here. Shemke. Thank you so much, Jedi. Thank you so much. Shemke. Shemke's not always getting in trouble. We're just always kind of talking smack to Shemke because Shemke reads the chat. He reads the chat. He's always on his phone. He might be the hardest defense attorney in the entire state of Michigan. He works so much. He's working on like 10 cases at a time while he's talking to a judge. He's on his phone working on a case. I actually have a lot of respect for Shemke. A lot of people talk shit about him. I don't. I actually really respect him. But yeah, Shemke, Chris Shemke. He's just I don't know. I feel like he's I don't know. I'm trying to think of an analogy off the top of my head where he's the easy guy to pick on, but he does his job. No hates him. No hates Chris Shemke. Hates him. Yeah. Shemke is the top level holder of all time for Candy Crush, according to No. But yeah, Shemke. Yeah, he's fun. He's fun. All right, let's go.
And that's why I'm here all the time, because you never know when they're going to arise. We are on the record, and the defendant is not here yet, but I'm going to call the case. Title of the case is People versus Janelle and Anthony. The file number is 241775FY. We have a host of people here. We have the entire public defender team, headed by Keith Stickley. We have Ross Truckee, who's been appointed to represent this defendant, substituting for Paul Gibson. We have prosecutor David Marvin. This is an emergency motion for, I'm not sure exactly what, modification of the bond. My understanding is the defendant was quite agitated at the time of her arrest. In fact, I'll tell you what I know about it. I was arraigning another person, and I called over and they brought a young woman, and they said, well, it may take a minute. We've got an unruly person coming from Three Rivers. I think I heard a little ruckus in the background. Well, that person was Janelle Anthony. I was at a meeting yesterday with the undersheriff, and he said she was still quite agitated. She's charged with assault with intent to commit great bodily harm, resisting, obstructing a police officer, ethnic intimidation, 2 counts of assault and battery. So we're about to bring her in. I asked the bailiffs to tell her that Judge Middleton wanted to see her and bring her in. So we'll see how this goes as I bring her in.
There he is for you. Hi, Middleton.
Good afternoon. Miss Anthony, can you hear me?
Yeah.
Okay, this is Judge Middleton. Hi, I wanted to talk to you. I've got a bunch of people here at the court with me. Mr. Keith Stickley, the Chief Public Defender, is here. Your attorney, Mr. Ross Truckee, is here. And prosecuting attorney David Marvin is here. Janelle, I don't know if you remember me, but I remember you from when you were.
I know my dad. I went to school with your son Alex. He was
Yes,
in my
I
home.
remember.
He was a good boy. I liked him.
Well, thanks. He's still a good boy. He just turned 40. All right. You're charged with some very serious charges.
Yeah, they were.
Assault with intent to commit great bodily harm, resisting, obstructing a police officer, ethnic intimidation, and 2 counts of assault and battery. The magistrate set the bond in the amount of $10,000 cash or surety, and Mr. Truckee made a motion, and he wants me to review that bond.
Thanks, Mr. Truckee.
Your Honor.
Yes.
I had the opportunity, sorry to interrupt, I had the opportunity to review the video from yesterday, the arraignment. And the same sort of thing that happened yesterday from my point of view is happening now. I don't know if she's aware of what's going on as she sits there. I don't know if she's on her page. I don't think she heard a thing he said. And I know anytime anybody can make a motion for competency, then I would suggest that she assess for competency.
All right, Miss Anthony. Janelle? All right. Janelle, I'm gonna let you go back to your cell. Brandy, you can take her back. All right, thank you. Well, that did not go well.
That is my exact point, legal fiction. And Mr. Marvin, I feel like he needed to shut up. I don't know why he felt it necessary to interrupt Judge. I'm gonna say Judge Washington, Judge Middleton. Judge Middleton was talking to her. Everything was going fine. He related to her, and I feel like now it makes sense. He has the perfect way of addressing defendants. He had her, she was responding to him, they were having a conversation. I feel like they may have been able to get through the arraignment. I don't know why Mr. Marvin decided that he needed to speak up there. There was no reason to. Absolutely none. The reason why I wanted to play this clip is, and I am very partial of this because I am friends with her, but that right there made me want Debbie Davis sitting in that chair over him. I'm sorry, I said it. I did. I don't like getting political, but I am friends with Debbie Davis, and that just showed me that Mr. Marvin has no idea what's going on. Sorry. You guys can disagree with me all you want, but that was inappropriate for him to do that, and it made things worse. And I will say that he didn't know that was going to happen, but he should not have stopped. She was talking. Everything was going great. Okay, let's finish this up.
Well, started all right. David, I don't think you helped anything. I was establishing some rapport and then it all sort of went sideways, but
I don't agree respectfully.
well, I guess you don't have to. I had given the floor to Mr. Truckee to make his motion and you said, I don't want to interrupt, and then you interrupted.
Your Honor, may I say something else?
Yes.
I was looking at the computer screen. I don't know what you're looking at, but I saw somebody who had her head turned away from you and did not hear words you said. And I don't know if you're looking at the
I
YouTube
saw
monitor or
the
what
same,
you're looking
I
at.
saw the same thing you saw.
I would like to inquire, Mr. Marvin.
All right, well, first of all, let's back up. You made this motion. I'll read it. You don't cite any authority. You just made a motion. The reasons for the modification of the bond are failure to effect a proper arraignment on the defendant within 48 hours. There exists an unreasonable delay due to the ill will of the custodial officer during the arraignment hearing. The defendant was under threat or coercion during the arraignment, and the officer's actions jeopardized her constitutional right to make statements freely. Magistrate Autumn Kiefer probably was doing the same thing I'm doing, trying to do the best she could with a mentally ill defendant. And the unreasonable delay is not unreasonable because the delay is due to the mental illness of the defendant. And Mr. Marvin, I think, is on the money that we need to probably have a competency evaluation sooner rather than later. So, Mr. Truckee, what were you asking me to do?
I was asking you to find that the arraignment that was offered and is being tendered as an arraignment within the 48 hours was not a valid procedure, not due to Miss Anthony's unruly conduct or mental illness, but due to the conduct of the corrections officers that were present in the holding room with Miss Anthony. Twice the taser was directed at her head.
Well, look back up. What's your authority for this?
Under MCL 764.13, 764.26, and People v. Cipriano all address the need for this 48-hour period. And it's United States and Michigan constitutions.
All right, well, let's take yesterday off the table for a minute. I just attempted to do an arraignment myself. The bailiffs were gentle with her. She was okay for a minute, and then she disassembled before our eyes. So whatever just happened was not as the
they're still trying to arraign her. So they haven't been able to get to an arraignment, and the defense is claiming that she was forced under essentially coercion. Now, I've heard that word pronounced so many times incorrectly, I'm starting to pronounce it incorrectly. They're saying that she had a taser to her head. We don't get to see that. We don't. That happened with the magistrate, whoever's the magistrate in that courthouse. That's where that happened at, and which is terrible to hear. And Judge Middleton tried to just get through the arraignment with her. And like I said, he started a rapport with her. It was going well, and then Mr. Marvin decided to interrupt. I still have no idea why he decided to interrupt right there. There was no reason to. The judge could have gotten through the arraignment before he said anything, before he asked him for his piece. All right. I need to get off my soapbox. I just don't like, I think he ruined it. I really do.
Result of conduct of the corrections officers. I asked the officer how she was doing. They said she was calmer today, but she had been crying all day.
Oh, she's not a former prosecutor, Phil. Phil, you've been gone for a little bit. She won the election. She is going to be the prosecutor. She won Mr. Marvin's seat. As of January 1st, Debbie Davis is going to be the, I don't know, whatever Mr. Marvin's position is now, the chief prosecutor, whatever the title is, that's what she's going to be as of January 1st. But yeah, she won the election.
She's obviously suffering from severe mental illness. Problem in today's world is we can't tell how much is mental illness and how much is methamphetamine or both. The current configuration of methamphetamine helps create schizophrenia. So I don't know if that's what we're dealing.
Yeah, you're right. She won their primary, and because there's no Democrats running, the primary was with 3 Republicans. It was Debbie Davis, Mr. Marvin, and the prosecutor that was in the position before Mr. Marvin won the last election. So the former prosecutor ran again, but Debbie Davis won as the Republican and during the primary, and there's no Democrat running. So, yes, technically you're right. I mean, I guess if Mr. Marvin just decides to run as a Democrat, he can be put on the election, on the ballot, but I feel like it might be too late for that.
With, or she just is schizophrenic. The charges are very serious. Assault with intent to do great bodily harm. The booking information indicated that she jumped on some lady's back and broke her collarbone and said a bunch of racially charged hate stuff and fought with the officers, and it was a bad situation. So what you're asking me to do is essentially give her a PR bond or just discharge her?
I'm requesting that she either be granted a PR bond in this case with the understanding that she's on bond in a circuit court case, and that PR bond may not mean her immediate release. But I think in this file, she was denied due process by failing to be arraigned and failing to be afforded the ability to meaningfully participate, even though her participation isn't going to be terribly meaningful. A taser was aimed at her during the arraignment. She was directed how to answer the magistrate's questions. And I don't think that in any way that can be found to be an effective process.
All right, well, the one we just did was, she's posted bond in the circuit court. As far as I know, there's been no motion to revoke that bond. I don't have the authority to revoke it. She's pled guilty, so she's no longer presumed to be innocent, so she's not entitled to a bond, but she has a bond and she posted it. Now that was, she pled on the 24th of September, and this incident occurred on September 30th. So I'm not sure what happened between the time she pled in circuit court and the time she got arrested in Three Rivers.
I would indicate, Your Honor, I'm in possession of a complaint regarding her conditional release from Officer Dibble. Due to this alleged conduct, he's seeking that in a circuit court case, and it's suspected it would be dealt with promptly.
All right, well, I'm going to deny the motion for PR bond.
I did have an alternative request if Your Honor would hear it.
All right, what's your alternative?
It may be based on the conduct during the arraignment, request that she be held at a different facility pending trial. It appears that it's unsafe for Miss Janelle Anthony at the jail.
I agree with that. Yeah, giving her a PR bond without having any information. I don't know. I don't know. If she has someone that comes and picks her up, because she's clearly not understanding what's going on. No idea what's going on with her. I don't know if she's detoxing right now, so she doesn't understand, or maybe it's something else. Who knows what's going on with her? But just giving her a PR bond and putting her on the steps of the jail, like, okay, you can leave. That's when how do you make that decision? And I think that's what's going through Judge Middleton's head right now. Yeah, release her to someplace else. Release her to someplace that's not a jail. She did do some horrible things. So a PR bond isn't really okay. You're not going to give her a PR bond. She broke someone's collarbone. You're not going to get a PR bond. But maybe jail is not the best place for her. I don't know. I'm not an attorney, not a judge. This is a difficult one. I told you at the beginning of it, it's a difficult one.
All right, so you make an oral motion on the fly for me to remove her from the jail. So I'm not going to grant that either. I don't know. I have faith in our jail staff. I know all of them. I knew the two ladies in the video. I don't know what happened yesterday. I know what I just saw. But the fact that we're going to get a competency evaluation is going to greatly delay this. And she's going to be sitting there. So I don't know if there's any evidence that she's being mistreated presently. I did talk to the undersheriff about her yesterday, and a couple issues. For the last several years, we've had Covered Bridge as our mental health liaison, jail diversion specialist at the jail. That contract ended September 30th, and a new contract began with Pivotal. And frankly, we've had some bumps in the road. I had asked someone for some help with Aaron Brown, and I made 2 requests last week with no response. Got a response on Lisa's last day, September 30th, and then I sent an email to the director of Pivotal saying, will someone please help me with this guy? He's sitting in jail and he's got some serious mental health problems. And I haven't heard anything back. So right now, mental health is Pivotal, our county mental health, who decided to not call themselves Community Mental Health, but Pivotal, is connected to Miss Anthony, according to your petition or somewhere. Vicki Merrill's, it's in the bond information form, from Pivotal is presently supervising her. She was apparently capable enough on September 25th to enter a guilty plea in I guess it was no contest plea in circuit court, and Judge Stutzman accepted it. I'm not sure, as I stated a minute ago, what happened between then and now.
All right. Judge Middleton just had a little Zoom, I don't know, camera mishap. But while he's doing this, I have made the decision. I am going to go to Detroit tomorrow. I'm going to go check out the 36th district. Yeah, I'm excited about it. Hold on. He's going to unmute, and then I'm going to pause. All right, I'll just pause now. Yeah, so I made a decision. I'm going to go up there tomorrow. I really want to, I just really want to see Judge King, see him in person, make sure he's good. So I will be in the 36th district tomorrow. If anyone wants to come hang out, come hang out. I messaged Judge Slavin. Judge Slavin says he's swamped tomorrow. His docket is booked. So that means he's on the bench. So I may, depending on what time I leave the 36th district, I'm going to go jump over to Taylor since it's only like 20 minutes from there. And then you know what? Who knows? Maybe I'll swing by Judge Simpson as well, because Judge Simpson is only 20 minutes from Taylor. It's all in a line. I don't know yet, though. I don't know what, but and see Judge King. So yeah, just made the decision. Gonna do that tomorrow. So let's go. Let's go. Mary Brown, kick her out of the jail. How rude. Thanks, Mary Brown. I appreciate the super chat. Thank you so much. All right. Okay. Just show your praise. Yeah, exactly. Yeah. Well, I've messaged Judge King, and so he knows I'm coming. I talked to him since I started going live, so he knows I'm coming. I wouldn't just show up without letting him know. I was gonna do that on his first day back, but then I got pushed out. So yeah. But anyways, I'll be in Detroit tomorrow, which means I got to stay up late and make a video to release tomorrow morning. Yeah. Okay. So let's do it. Let's do it. All right. Let's finish this clip, and I got to go to bed because now I got to wake up at 3 a.m.
All right. Do you have a position regarding Mr. Marvin's request for a competency evaluation?
I'm not able to take a position on competency at this time. I was appointed to this afternoon. I've got to meet with Miss Anthony before I can speak on it.
All right. I'm denying the motion to amend or change the bond.
And the only further request I have, Your Honor, is that this court review the video of the arraignment.
As I said, I'm not worried about that arraignment. I'm worried about the one I just did.
I understand.
So I'll say I would set a $10,000 cash or surety bond based on the conduct, based on the fact that she was on a felony bond and had pled guilty 5 days before, based on the fact that someone had a broken collarbone. So if you want, I will set bond today.
Well, I might end up with a similar objection to this arraignment. But I would note that the conduct here was much different from the corrections officers.
All right, well, 10,000 cash or surety with the same conditions. It's greatly against the public interest to put this young woman out on the street. And it's against her interest.
If anyone wants to come down and hang out with me, how about this? When I get there, well, I will post a community message when I leave, and I'll say when I'm expected to be there. I like getting there at about 8 a.m. before the court starts, just so I can get a parking spot right across the street from the court. It's only $8, but you got to get there early because it fills up quickly. So, yeah, if anyone wants to come hang out with me in the 36th district tomorrow, I will be there between 8 and 8:30. Find me on Discord if you're going to come, so I know to look for you. Just find me on Discord and just send me a DM. Just let me know you're going to be there. But yeah, anyone's welcome to come hang out.
There's not a petition for hospitalization. She's on a personal recognizance bond in the circuit court. And if I were to grant your motion, she would be standing on the front steps of the jail in the condition that she's presently in. And I'm not willing to do that. And we're not talking about shoplifting or running a stop sign. She is accused of seriously injuring someone. And there's.
Oh, don't do that. Does he really? What's tomorrow? Tomorrow's the 4th. Let's see. I'm looking at my calendar of stuff. I don't have anything written down for Judge Simpson tomorrow. October 1st, that's past. 3rd, that's past. That was today. I don't have anything with Judge Simpson tomorrow. But if you're going to tell me he has an interesting case at 2, I'm going to go. Yeah. Looks like I'm going to Judge Simpson too if he's got a good case at 2. Man. so much for a quick up and down. Detroit's 3 hours from me. So Detroit's 3 hours. Then Taylor is about 20 minutes west of Detroit. It generally takes, I think the last time I went there, it took me about 30 minutes to go from the 36th district to Taylor. But then to get to Judge Simpson's courtroom is about the exact same west. But weirdly enough, it was still 3 hours back home. So, looks like I'm going to visit Judge Simpson. I am terrified Judge Simpson's going to hold me in contempt of court, though. Now that he knows who I am, yeah, I might get arrested at Judge Simpson's courtroom. You know what? Let's go. Let's go. Will you guys bail me out if I get arrested at Judge Simpson's courtroom? You guys better bail me out. Just saying.
The public protection interest here and an interest to protect her. And I had this discussion with the sheriff yesterday, acting Sheriff Bingaman. Our jail is the largest mental health facility in St. Joe County. Of the 93 people in there, probably about 40 of them have mental health problems. Some of them are quite acute. And she certainly is. So she's connected to Pivotal. She is in a position where.
All right. The reason why I say Judge Simpson might hold me in contempt is he had no idea who we were when we showed up. And as I said a little bit earlier, Miss Ann, his court coordinator, asked me if I was Colin because his chat was open and he was saying, and everyone was saying, Colin's there, Colin's there. So she asked me if I was Colin. And then she asked me to send her, well, she asked Sly to send her pictures, the pictures that we took, because she wanted them. And I actually sent her the pictures. So I sent her the pictures plus the video of the court crawl that I made. And one of the videos, one of the clips in the court crawl montage was, I'm not going to say it was illegal, but it may have been a hidden camera underneath a purse taken of the buff lift. And yeah, they never responded to me. So just saying, I'm not exactly sure how I'm going to be welcomed in that courtroom, but you know what? Let's do it. Let's do it. Let's see what happens. It could be fun. I might get arrested by the buff lift tomorrow. Yeah, let's go. I'm telling you guys not to do anything dumb, and I'm about to make a dumb move.
She can't harm anybody. I don't know if Pivotal would petition for hospitalization. They could do a police petition, or someone could petition or hospitalize her. As you all know, once you ask for a competency evaluation, it takes a long time to get there. Mary Finney was in jail for like 400 days before she got her competency evaluation, and she's not competent. So at any rate, the bond is set at $10,000 cash or surety with same conditions. The motion to transfer from jail, St. Joe County Jail, is denied. If there's additional evidence presented that she's unsafe or being unfairly treated at the jail, but she's just going to take her current problems to whatever jail I put her in. There is an option that somebody could petition for hospitalization. Mr. Marvin's motion for competency evaluation. I'm going to take that under advisement. Miss Anthony is set for a pre-exam conference for October 15th.
Stop it.
Anytime before then and now, we can review it. She is working with mental health. Or I'd like some input from them. And I don't know. She's been like this for 4 days. I don't know that she's instantaneously gonna go into remission. I don't know enough about what's going on. But obviously, what we all saw certainly begs for a competency evaluation. But Mr. Marvin, I think you made it in good faith. I'll take it under consideration. We can review it again between now and October 15th. And I'd like some input from CMH. Also, Judge Stutzman's going to have a problem. Someone from the Department of Corrections is going to be tasked with doing a pre-sentence investigation report on the case that she pled to, and thinking of a sentence on November 1st.
Listen, I didn't do anything. Well, I did, kind of. I'm going on a court crawl tomorrow. I'm going to head up to Detroit, hopefully stop by Taylor, and then maybe end up the day in Washtenaw with Judge Simpson. And I don't know how Judge Simpson is going to react when he sees me. I have this like itch in the back of my brain that tells me not to do it, because I don't know if Judge Simpson is too happy with me. So we'll see how that goes down. But yeah. So I didn't do anything. It was Sly. Sly did it. Sly's the one who recorded in court, not me. I just put it in a video. It wasn't me. It's Sly's fault. Arrest Sly. I'm a snitch. I snitched on Sly. It's her fault. I just pointed next to me like she's sitting next to me. She's not here.
That could very well result in a report of competency concern.
Yes, he has the same problem I do. So perhaps if there's going to be a competency petition, it could be done in both files. Anyway, let's see how this goes. Hopefully, she will be prioritized by the female corrections officers. They do have at least one female on every shift. So, Mr. Truckee, you are doing your job that you're appointed to do, to look out for the interests of your clients. But I don't think it's in the best interest of the public or her to grant your motion. We can certainly revisit it. And I'll revisit your motion to move her to a different jail. And let's assume that there was some defect in the earlier arraignment, which, for just sake of argument, as I indicated, I heard some of it when she was coming in there. She was quite agitated on the way into the jail.
Oh, terrapins! I love the terrapins. I love turtles. I love all kinds of turtles, especially the terrapins. Just don't ask me any questions. No idea where the university is. I know it's in Maryland, and I know their little flag is that weird, like, multicolored shield with the Maryland colors. Yeah, Judge, terrapins, go turtles. We have turtle videos on my channel because of the turtles. We love you, Judge.
I have the authority to set the bond. And for the reasons I stated, I would set the bond in exactly the same amount with exactly the same conditions based on what I just saw. So let's see what happens between now and October 15th, or any further motions, but I'll do a written order denying your motions so you can appeal it or ask for something. But she is not in a position to be released into the public. And I guess mental health or you guys or somebody can consider a petition for hospitalization short of a competency evaluation. But I don't, if there's a motion in circuit court coming to cancel her bond there, it probably isn't going to happen anyway. So it is unpleasant to see Miss Anthony in that state. Let's hope she can get better. All right, that completes this record.
All right, yeah, sorry. I kind of lost track of what the video we were actually playing because I am now I've been trying to figure out what I'm going to wear tomorrow. So I have not been paying attention for the last couple minutes. But as you can see, the video's over. Going to Detroit tomorrow. Yeah, I got nothing else. Let's see. Who can we potentially raid? Is anyone still online? 9:30. It's probably pretty. I don't think there's going to be anybody. Oh, Katie. Yep. All right. I got it set up to raid KDZ. So we're going to do that. Yeah. So I'm going to be in the 36th district, downtown Detroit tomorrow morning. If anybody wants to come with, feel free to come with. As of now, this might be the first time I've actually done this trip alone, which is fine. But if you guys want to come with, feel free. If you're in the area, just look me up on Discord so I know to look for you. If you don't have Discord, you don't know how to do that, just look for the 6'3" tall dude. I'm gonna be wearing a tie tomorrow, and I'll be walking in the door. I'm gonna be wearing the brightest color I have. Hopefully, it's not the same teal shirt. I think I have a bright purple. I don't want to wear purple. Trying to think, I don't have any other bright color shirts, and I don't want to wear the teal shirt again. All right, I might actually not be wearing a bright color. It might be a dark color. I'm thinking black or blue. Anyway, sorry, I'm just thinking. Just look for the tall guy. Yeah. Okay, that's all I got. We're gonna go raid Katie Zed. Looks like she's still playing, so we're gonna go raid her. Thank you guys so much for hanging out. Thank you guys so much for the gifted memberships. You guys killed it tonight. Gifted memberships. Thank you so much, Mary, for the super chat. The membership milestones. You guys are awesome. I will see you guys tomorrow. Hopefully not in jail clothes. I'm teasing. Judge Simpson's not gonna put me in jail. I gotta put that out in the universe. I got to. All right. I'm going to bed. You guys have a great night. Thank you so much. Until next time, bye.